Cell doors don't usually close on the defense. That's not how the story goes. That's not the movie. The defense is supposed to argue, posture, object, roll their eyes, maybe get a stern warning, maybe a fine, and then everybody goes out for lunch. That's the rhythm. That's the dance. Except yesterday, the music stopped. Because yesterday, inside a federal courthouse, U.S. Marshals physically removed defense attorneys from Judge Sarah Caldwell's courtroom and walked them straight into holding cells. Not as defendants, not as witnesses, as lawyers, handcuffed, processed, locked in. And if that sentence made you sit up a little straighter, good, because that reaction is exactly the point. When a judge orders the defense detained mid-trial, something has gone catastrophically wrong. This wasn't a tantrum. This wasn't a misunderstanding. This wasn't a lawyer talking a little too much or pushing a little too hard. This was a slow-motion collision that everyone in that courtroom could see coming, except, apparently, the people who drove straight into it. And here's the part that keeps sticking in my head. Judge Caldwell didn't flinch. She didn't raise her voice. She didn't threaten. She didn't negotiate. She issued the order. Marshals moved. Cell doors closed. That was it, like someone flipping a switch. So let's talk about how a defense team managed to get itself jailed in federal court, because this didn't happen in one moment. It happened over weeks. Weeks of warnings. Weeks of chances. Weeks of a judge saying, in increasingly clear language, "Stop doing this or there will be consequences," and a defense team responding again and again with what can only be described as professional chicken. This trial was already combustible. The defendant, Raymond Voss, isn't a nobody. Former senior aide to a major political figure. Money, connections, allegations that read like a greatest hits album of federal charges. Wire fraud, obstruction, conspiracy. The kind of case where every ruling gets parsed and every sidebar feels loaded. From day one, the defense posture was aggressive. Not just aggressive in the normal way, but theatrical. Every ruling was treated like a personal insult. Every denied motion was a provocation. They weren't just defending their client. They were daring the court to react. Judge Caldwell, for her part, is not a hothead. She's known for being controlled, precise, almost clinical, George W. Bush appointee, reputation for tight courtroom management, the kind of judge who gives you rope and watches what you do with it. And boy, did she give them rope. 3 weeks before the removal, she issued a pre-trial order excluding certain material she ruled prejudicial. Clear order, plain language, don't reference it, don't allude to it, don't wink at it. The defense referenced it anyway, 3 times in their opening statement, right out of the gate. Caldwell stopped proceedings, called them to the bench, and put them on notice. On the record. The kind of warning that isn't subtle. "One more time," she said, "and I will find you in contempt. Do you understand?" "Understood, Your Honor," the lead defense attorney, Marcus Renard, said. The very next day, he did it again, in front of the jury, during cross-examination. At sidebar, when Caldwell called him out, Renard didn't apologize. He didn't back down. According to the transcript, he told her respectfully, sure, but very clearly, that he believed her order was wrong, and that until it was reversed on appeal, he was going to present his defense as he saw fit. That's not how this works. That's not how any of this works. A federal courtroom is not a suggestion box. You don't get to decide which orders you'll follow while you wait for an appellate court to maybe agree with you someday. And Judge Caldwell made that very clear. She sustained the objection. She instructed the jury to disregard. She issued a formal contempt warning on the record. That should have been the end of it. Any sane attorney would have pulled back, recalibrated, found another angle. They did the opposite. Over the next 11 court days, the defense racked up what Judge Caldwell later cataloged as 17 separate violations. 17, talking over her rulings, continuing arguments after objections were sustained, refiling motions that had already been denied, addressing the jury after being told to stop. On one day alone, Renard kept speaking for nearly 40 seconds after she sustained an objection, forcing her to interrupt him repeatedly. The transcript literally notes that he continued speaking over the court 6 times that day. That's not advocacy. That's defiance. Then came the moment that ended everything. During routine testimony, the defense introduced an exhibit that had been explicitly excluded, not weeks earlier. That morning, 3 hours earlier, Caldwell had ruled it out in plain English, no ambiguity. The prosecutor objected immediately, and instead of stopping, Renard turned to the jury and said, "Ladies and gentlemen, the court doesn't want you to see this, but I believe you deserve the truth." If you're a lawyer watching this, your stomach just dropped. If you're not a lawyer, trust me, that line is legal gasoline. Judge Caldwell called an immediate recess, cleared the courtroom, jury out, gallery out, press out. For 45 minutes, the room sat empty except for the judge, her clerks, and the attorneys. When the doors reopened, 4 U.S. Marshals walked in and positioned themselves behind the defense table. Renard reportedly smiled at them. He stopped smiling 8 minutes later. Judge Caldwell read from the bench. Calm, methodical. She walked through the timeline, every violation, every warning, every fine, every chance she gave them to correct course. She cited the standard for criminal contempt. She explained carefully why civil contempt and monetary fines had failed, and then she said it. "Counsel, you have left this court no choice. You are held in criminal contempt. Marshals, remove the defense." Handcuffs clicked shut at the defense table, in front of the jury, in front of the defendant, in front of a gallery that had no idea it was about to witness legal history. They were escorted out and processed through the courthouse holding facility. Cell doors closed, 6 hours in custody before a magistrate judge set bail. Let that sink in. Defense attorneys went to jail because they refused to follow court orders. Now, before anyone starts yelling about tyranny, let's talk context, because context matters. This wasn't Judge Caldwell losing her temper. This wasn't a single heated exchange. This was a documented pattern of willful defiance designed, according to multiple legal analysts, to manufacture appealable error. The strategy wasn't subtle. If you can't win the trial, break it. Force the judge into drastic action. Then argue that the drastic action itself is grounds for reversal. It's a dangerous game, and it assumes the judge will blink first. Judge Caldwell didn't blink. She warned them explicitly in a pretrial conference. She said she would not be baited. She said she would not allow the courtroom to become a circus. She said there would be consequences, and then she followed through. That's why the 18-page contempt order matters. It's not emotional. It's surgical. It's a checklist of misconduct. 17 violations, dates, quotes, transcripts, opportunities to comply, escalation documented step by step. Legal historians are already comparing this to infamous contempt cases from the past, and the difference is striking. In the Chicago 7 trial, contempt became a weapon wielded impulsively, often unfairly. Judge Hoffman's behavior overshadowed everything and turned defense attorneys into martyrs. Caldwell did the opposite. She built a record so thorough it's almost boring. Almost. And that's why appeals courts take it seriously. Even commentators who are usually sympathetic to aggressive defense tactics are admitting this crossed a line. A court order is a court order. You don't get to ignore it because you disagree. That's not civil disobedience. That's contempt. Now here's where it gets even more self-inflicted. After being released on bail, Marcus Renard held a press conference. On the courthouse steps, cameras rolling, voice shaking with anger. He called the removal judicial tyranny. He accused Caldwell of bias. He framed the contempt findings as political theater designed to intimidate defense attorneys nationwide. What he did not do was address the 17 violations in the order. That's a problem. Because judges read press conferences. Bar associations read press conferences. Appellate judges definitely read press conferences. And when you attack a judge instead of engaging the record, you make yourself look exactly like what the judge said you were. Someone who refuses to accept authority. Legal ethics experts were blunt. That press conference will be Exhibit A in any sentencing memo. If he had expressed respect for the court while preserving his appellate arguments, that's defensible. This is gasoline on the fire. The fallout is already spreading. Bar associations have opened inquiries. The American Bar Association is reportedly preparing guidance based on this case. Defense attorneys across the country are rereading contempt standards like they're studying for finals. Meanwhile, the underlying trial is in limbo. Judge Caldwell declared a mistrial. The defendant has new counsel. Motions to dismiss have already been filed, arguing irreparable prejudice. Prosecutors oppose, saying a defendant shouldn't benefit from his attorney's misconduct. And here's the subtle but important part. Caldwell's order specifically notes she found no evidence that the defendant directed or was aware of the strategy. She's insulating the case against claims of entrapment or bad faith. That's not an accident. That's foresight. So what happens now? The defense attorneys face criminal contempt proceedings before a different judge, possible jail time, almost certain bar discipline, careers hanging by a thread. The defendant likely faces retrial, and the rest of the legal world is left staring at a moment that changed the balance of power in federal courtrooms. Because whether you like it or not, a line was drawn. You can push, you can argue, you can advocate aggressively, but you cannot openly defy court orders and expect immunity because you wear a suit and carry a briefcase. Cell doors closed on a legal strategy built on chaos, and every attorney watching just learned where the line is. If you want to see how this plays out, stay with me. Appeals are coming. Sentencing is coming. This story isn't over, but one thing is already clear. Judge Caldwell didn't just hold lawyers in contempt. She reminded the entire system who actually runs a federal courtroom. Subscribe, because the next chapter is going to matter.